Shri Abhishek Singhvi.
वो थे उनके प्रेजेंट थे they were present. Some of the man was present. Mr. Chairman, sir, I am grateful for this opportunity to respond. I have heard my friend in rapt attention, and despite the several fallacies of his argument, each of his points requires very specific response. The Office of Profit has acquired an acronym OOP, which is perhaps reflective of the chaos and the confusion. If you pronounce that acronym OOP, the chaos and confusion is inherent in the acronym itself. But my friends on the opposite side are obviously trying to contribute more and more to that chaos and confusion. From a discussion of a bill on the Office of Profit, they have repeatedly tried to convert it to a discussion on a bill of perplexity and pandemonium. But may I deal with the issues on three fronts. My friend challenged the manner in which this House is proposing to deal with this subject and to pass or not pass the bill. And he then dealt with the merits of the matter. So may I firstly start with the manner of passing of this bill. My friend referred to it being a bad day for Parliament. I asked him and his supporters, is it very glorious for you to have participated through no less than the leader of the opposition in meetings which pre-decided that the Office of Profit Bill will be taken up sometime today, and then to renege on a commitment which your party's senior representative had made along with others? Is it fair and glorious for you to draw the equation in an either-or format, either terrorism or Office of Profit, where there is no mutual exclusivity between the two? There is no question of both not being important. There is no question of this House not discussing both. You heard the minister a short while ago saying that we shall sit as late as we like to discuss terror, which of course, as you know well, has been discussed yesterday in some detail. Therefore, where is the question of either or? Where is the question of a choice? Both as parliamentarians, as commonsensical citizens, and as lawyers, we know that there is nothing sacrosanct about 31st. If the Election Commission is given time 5, 7, 10 times earlier, it is entitled in its own discretion to give time. And I don't think they are going to consult you before they give or do not give time. So why do you interpose this hypothetical situation, create a red herring that this House wants to discuss this now to prevent something happening on 31st or to have something happening on 31st? The date of 31st, my friends will permit. I am sure if you have the, I am sure that if you have, I am sure if you have had the patience to hear to your party member, you will have the courage to listen to a different viewpoint. Yes, right. I am sure that you subscribe to Voltaire's view as parliamentarians, that you disagree with me vehemently, but will support my right to speak, and to speak in patience without interruption, if I may respectfully say so. As just a few moments ago we did when the honourable member from your party was speaking. Now you talk of the manner of passing of this bill. Is it very glorious for you not to follow and not to support a repeated ruling of the chair That perhaps is your idea of parliamentary democracy. Not to follow a ruling of the chair, to obstruct the House or to walk out on other issues, when both terror and office of profit are liable to be discussed today and shall be discussed today. And shall be discussed today.
बोलने दीजिए ना उनको,
प्लीज
बोलने दीजिए आप बोलने दीजिए, क्यों बीच में
मैं उन्हीं
कमेंट करते
मुद्दों पे
हो?
बोल रहा हूँ,
आप बोलिए।
एक उसी मुद्दे पे बोल रहा हूँ जिस मुद्दों पे माननीय मेंबर ने अभी बोला था आपकी तरफ से। मैं एक मुद्दा भी बाहर से नहीं ले रहा हूँ। So therefore, do not try to mislead the public or the nation about the manner. The manner is the only democratic manner of passing it. On the contrary, if I may say so, you are responsible for obstructing the House, for delaying proceedings, for taking up valuable parliamentary time and painting a picture of an either-or situation where none exists. Coming now to the second issue which has been involved, and that is the issue of parliamentary passage of a bill, presidential assent or non-assent, and the entire procedure of Article 111. My friend, to whom I listened with rapt attention, unfortunately, is guilty of fallacy upon fallacy. And let me list you a few of the fallacies and then deal with them one by one. His first fallacy is implicitly right through his address that Parliament does something wrong if it even dares to discuss a matter and then to pass a bill which has been returned to Parliament by the President. That is the implicit theme of his address, that in doing so, Parliament is doing something unconstitutional, Parliament is doing something wrong, Parliament is doing something erroneous. The second fallacy, that's implicit in what you said.
Don't answer an argument I have not addressed.
That is implicit in what you said, because you are painting a picture of Parliament versus the President, which is precisely what the equation is not there. It is the same equation which you painted when you just said a moment ago, either office of profit or terrorism.
No, leave it. Mr. Vailar Ravi, please, Mr. Vailar Ravi, please.
Can I remind my learned friend?
Mr. Jetli,
Can I remind my friend? Can I remind my friend that it's the same equation
No,
of
he has
either or.
not intervened. Why? Please don't.
It's the same equation of either or which you are trying to paint in every situation. Third fallacy, the party in opposition will say that a bill is unconstitutional and that will make it unconstitutional. By definition, an unconstitutional bill should not be passed by Parliament. But why is it unconstitutional? Because you say so. Yes. As Alice in Wonderland said, something is wrong because I, Alice in Wonderland, say so. But what is unconstitutional about it? Let me remind the honourable member and his party that unfortunately for you and perhaps for us, the person or the entity which decides constitutionality is yet to come into the picture. And it comes into the picture not when a document is a bill, but when it becomes an act. And that entity is the Supreme Court of India. So let us wait for the Supreme Court of India to pronounce it unconstitutional or to validate it. Let us not give advance certifications in a self-serving manner and then say it is unconstitutional and then say we should not pass it. If this is so, then you would be deciding what, unfortunately for you, the Constitution is entrusted to the Supreme Court. The next fallacy, that there are limitations on parliamentary power. And as far as two limitations are concerned, I entirely agree with you. But unfortunately, you've smuggled in a third limitation. The two limitations are legislative competence, which is not an issue today. We are not transgressing or encroaching on any state power. The second limitation is that ultimately whatever Parliament passes will be held or not held to be constitutional by the courts. So there is a limitation of ex post facto judicial review. But let me remind the honourable member and the party he represents that there is no third limitation on parliamentary power. Article 111 is certainly not that third limitation. Presidential reference back is certainly not a third limitation. Article 79 is certainly not a third limitation. Indeed, my friend's arguments suggest a complete vote of no confidence in the House and the Parliament to which he belongs. It suggests a vote of no confidence in the very institution of Parliament. But let me remind you, merely because, for whatever reason, you happen to be one of the few parties in this House which has decided to oppose this bill, let not hard politics make bad convention bad precedent, bad law. You are dragging the president and the office of the president into a political arena. In the last few days and weeks, I have heard with astonishment arguments why the president should not refer this bill for advisory jurisdiction to the Supreme Court. I have heard with astonishment arguments that the president can or should override parliament. It was the topic of a television debate. I have heard issues as to whether the president can delay such matters. Why are these issues being raised? These issues are being raised because you have deliberately misled the nation and this House on the meaning and scope of Article 111, with which I wish to start. Now, it's interesting that if you'd done your constitutional homework, you would have emphasized the last 5 words of this article. And the last 5 words of this article are so unusual as not to be found virtually in any provision of the Constitution, virtually in any other constitution of the world. Those words are, if I may remind you, and I'm sure you haven't forgotten, but you have conveniently overlooked them in your addresses. The President shall not withhold assent. Surely, we, you, the House, the President, the nation is bound by the words of this small book which we call the Constitution of India. And let me remind you of another part of your constitutional homework. These very 5 words were missing in the draft article which came for approval before the Constituent Assembly. The Constituent Assembly, prior to Article 111, had before it Article 76. And if you read the books on this, you will find that Article 76 in its original form did not have these crucial words. A debate arose, an issue was joined, and it was said that ultimately in this country, for right or wrong, for good or bad, we have adopted a constitutional system of parliamentary democracy under which, barring 2 or 3 exceptional situations, the President of India follows the system of a constitutional entity and does not rule but reigns. He follows by 400-year precedents broadly the contours of the status of the Queen of England. And therefore, after the article did not have these words after discussion were inserted. What does that mean? For you it means that you are guilty just now of advocating a deliberate violation by this House of presidential of the intent of the framers. You want to violate the spirit and letter of the intent of those who framed this Constitution. The third aspect of Article 111. Article 111 represents the dialectics, the constitutional dialectics of give and take. In the Marxian terms, it represents the thesis, the antithesis, and the synthesis. That's the Marxian dialectic. But there is a dialectic in this constitutional process also. The Constitution envisages, knows, accepts all along that there may be situations where the Parliament and the President may differ. It doesn't mean that either is wrong. It doesn't mean that either is right. It only means that each is a high constitutional functionary entitled to the highest respect, the highest reverence, and the highest consideration. But ultimately, for those who decide, the framers could not have left it as 2 disagreeing institutions. So having anticipated the potential disagreement between these 2 institutions, the framers created this mechanism and added a proviso to Article 111. And indeed the proviso did not have these words, but these words were added precisely to envisage the situation which you call immoral, wrong, and you suggest that the President, having spoken on it, this House cannot or should not debate it. The fact that I am debating this or that you are considering it is not the slightest disrespect to the highest holder of the executive office in this country. On the contrary, each and every concern of the President of India has been and must be taken into account. But will that attenuate or circumscribe the sovereign power of Parliament, which has been entrusted to this body by the Constitution itself? Because if you say so, then you express a vote of no confidence in Parliament, you express a vote of no confidence in the Constitution, you express a vote of no confidence in those who framed the Constitution and expressed this intent so clearly, so categorically. But let me continue into how you have dragged the President into this political arena. Very wrongly. You are aware that the President has a right to send it back for reconsideration. You are equally aware that we have a right to consider and then decide as per the wisdom of this House. The President chose to send it back. And let me say here that I totally disagree with your picture that the President, in sending it back, has written down that the bill is unconstitutional. That is completely misleading again. Please see the President's referral back. There is no question of assuming that the President thinks or says that he thinks that this is unconstitutional. But I will come to that in a moment. When the President sends it back, I'm glad you are using, I'm glad my friend is using such good words, because if you believe in those good words, you should not have dragged the President into the political arena. You should not have dragged the President into the political arena.
Mr. Jyoti, please. Mr. Jyoti, please.
The President sends it back on a referral. The referral is to be reconsidered by Parliament under this article of the Constitution. While the matter is pending in Parliament, while Parliament is seized of the matter, you choose to go public and you choose to go to the President to suggest various alternatives to the President, while the President, quite rightly in terms of the Constitution, has left it for the time being with Parliament. Is this glorious? Is this correct? Is this a following of the parliamentary procedure? Is this an adherence to high standards of public life or the constitutional spirit? You could as well have waited for Parliament to debate it. You tried to preempt. I heard with equal astonishment, utter amazement, your suggestion that the President can and should refer it to the Supreme Court. For this argument, you pressed into service the office of oath. There lies another fallacy. But that fallacy has very grave implications. The fallacy is your premise that the President is entitled under the Indian Constitution to be a judge of potential legislation by referring to his oath. Now forget this case for a minute, because we tend to become exacerbated and excited about the facts of a particular case. But please appreciate the implications of what you have said. If this is correct, then every proposal, every bill from Parliament can be judged by the President by reference to his oath. The President will decide by reference to his oath, according to you, not according to the President, that a bill is unconstitutional, violative of Part 3, or that it shockingly violates his oath, and therefore, having so decided, will not give assent. The Supreme Court is, of course, to become irrelevant. But more than that, there is absolutely no power in the Constitution, and the President rightly recognizes it, and all our presidents have rightly recognized it till now, but you don't recognize it, that the President has no power under the Constitution to refer and decide matters by reference to a third entity known as the oath. This will convert our parliamentary democracy, our constitutional ethos, our spirit of our Constitution into a totally different field. It will maybe convert it into a presidential system, partly of the US kind. It will maybe make it a hybrid which belongs to no species and no category. But it will certainly do violence to the very basis on which our constitutional structure is premised. So, your reference that the President should consider referring it to the Supreme Court is deliberate mischief. You are also equally aware of the fact that this question of what the President can or cannot do arose in several situations. And ultimately, 25 or 22 years from before today, way back in 74, is nothing new. It was decided even before 74, but it was conclusively settled to rest by the Indian Supreme Court that these questions of the President acting on his own under Article X and Y and being bound under Article A and B will arise frequently. It's a usual thing. And therefore, if it arises, we must definitively settle this issue and decide in what situations the President can act individually. And Shamsher Singh's case, way back in 1974, not 2, not 3, not 5, but 7 judges laid down the law of the land, which has withstood the test of time today after 22 years, and they said, barring the situation where the President may decide on his own in a dissolution case, or where the incumbent government has lost its majority, the President shall always act on the aid and advice of the Cabinet. And if that is so, where is the question of your going to the President or to the press and suggesting that the President suo motu and separately on his own shall approach the Supreme Court under whether Article 143 for advisory opinion or anything else. Now, to that, Article 79 is no answer. The answer you gave is irrelevant as far as the presidential power is concerned. Article 79 simply says that the President is part of the parliamentary process so far as passing of a bill is concerned. But that is axiomatic. It has been known to us since 12th century, when the British Queen was also treated as part of the Parliament, that the one or the two houses will pass a bill and the President or the Sovereign will assent to it. In that sense, they are part of a parliamentary process. But that does not mean, and no President has ever suggested that it means, and no one else has said that it means, that the President shall have individual discretion in respect of bills. So that again is highly mischievous and misleading. But let me remind you that you have not only raised this issue, but you have obstructed Parliament on this issue. You have sought to go to the public and the press by suggesting that referral of this matter to the Supreme Court by the President without the aid and advice of the Council of Ministers is permissible. And let me remind you also of more recent law, definitive law on this subject. You mentioned Article 79, completely irrelevant and unrelated to the subject. But let me remind you again of judgments which have drawn a very, very sharp distinction between the power of the President under 111 and the power of the President under some special provisions where he does have individual discretion. And that's a very interesting theme, which again makes the precise point which this government is seeking to make and this House should make. And that is this: the President under 111 can return. The last four words say that if it is returned back by the House, the President shall assent to it. This the Supreme Court, not me or you. I will not. I'm sorry.
He is not yielding.
You will have your turn.
Mr. Jyoti, your name is there. No, your name is there. You have patience. No, you have patience. Mr. Jyoti, no, Mr. Jyoti, no, I will not allow. Nothing goes on record what it is. Mr. Jyoti, Mr. Jyoti, you are speaking. No, you are speaking. You are going to, your name is there, then you can respond. Don't intervene, don't respond. Whatever it is his opinion. No, you cannot say that. You cannot say that. You have no right to say that.
My friend will.
No, that is all right. That is, you can also say, you can't say that.
My friend will do unto others. My friend will do unto others, including me, what he would have me do unto you. The Supreme Court has described the power of the President and the power of Parliament precisely under this very provision, 111, as compulsory assent. Compulsory assent, and if you want to check up the law, I don't want to get technical, it is by 5 judges. In 2002, in 2002,
no, Mr. Abhishek Singhvi, you please don't respond to him. Please,
in 2002, 8 SCC 182. If you want the paragraph, it is 76 and 77.
You place your points, but don't respond to him.
And what did the Supreme Court say? No, I'm not responding to him. It said, and I quote, being an exercise pertaining to expression of political will, apparently the will of the people expressed through the legislation passed by the elected representatives is given prominence by specifically providing for compulsory assent or compulsory consent. But it did something more. In the next paragraph, it did something remarkable. It drew a distinction between other provisions where the President does have some discretion. For example, when a state legislation or a state law potentially may violate central law and it is reserved for the assent of the President under a different Article 254, the President would have a different approach and a different discretion. That makes the precise point that today, to draw the President into the arena, the political arena, by suggesting what? By suggesting that the President should refer for an expert opinion, the President can override Parliament, the President may delay, the President may refer to an oath. These are extraneous, irrelevant, misleading matters, and they do not deserve the attention of this Honorable August House. But let me go further and remind you that the House is ultimately the house which takes responsibility about the validity or otherwise of a bill. The House, when it passes any legislation, knows that it is ex post facto in future that the courts may or may not strike it down. The House cannot be deterred in advance by merely creating cobwebs and ghosts to suggest that it is unconstitutional. The President has nowhere in his reconsideration letter or his reconsideration reference so suggested. Therefore, my friend is deliberately creating a ghost of a fear of unconstitutionality and then shooting it down. But may I now turn to what is the matter as far as the Office of Profit Bill itself is concerned. The Office of Profit Bill again is nothing but a simple exercise of power under Article 102. And just like you must come back to the constitutional text under Article 111, you must come back to the text under 102. And again, as we all know, and as we debated in the earlier round, the words there are significant: other than office declared by law by Parliament not to disqualify. Now these words are added for what reason? These words have been added for the reason that uncertainty will arise in the future whenever you are not aware of the post. The Constitution could have itemized these posts. The Act could have itemized these posts. But the Act and the Constitution decided not to itemize these posts because they had to deal with future uncertainty. Because the framers decided that in future situations will arise which will require flexibility and will require a decision on what to add and what to subtract.
Narayan Swami, Mr. Narayan Swami, you go, come here. Otherwise the House will be disturbed.
Let me address the three issues raised by the President. Let me address the three issues raised by the President and presented in a somewhat distorted fashion by my learned friend. The first issue of retrospectivity. The views of the President are entitled to the highest respect. But my friend himself accepts and admits that there is a judgment of Kanta Kathuria which validates retrospectivity in respect of an Office of Profit Bill. What happened in Kanta Kathuria? A lady was elected MLA, but she also drew honorarium and perks as a government advocate. After the challenge, a law was passed. The law was challenged on the ground of retrospectivity. It was upheld. My friend brings out a test. The test which he brings out, the test which he brings out is a test of nexus. My friend says that there should be a nexus between the post
Your
and
friend
the
has
parliamentary
left.
duty.
Your friend has left.
जिसको आप अगर देखिए मैदान छोड़ के जाने का क्या मतलब होता है?
Please, order please.
मैदान छोड़ के जाने का क्या मतलब होता है? देखिए, मैदान छोड़ के जाने का क्या मतलब होता है वो आप सब जानते हैं, लेकिन कम से कम आप लोग यहाँ हैं तो मैं समझता हूँ कि जो मैं बोल सकता हूँ मैं संक्षेप में बोल दूँ. दी आर्गुमेंट नहीं, अगर आप उनको डिसोन करते हैं और मेरे से सहमत हो तो मैं बैठ जाता हूँ. अगर आप उनको डिसोन करते हैं मैं बैठ जाता हूँ.
नकवी साहब बैठे.
उन्होंने 3 मुद्दे रेज किए. एक मुद्दा कहा कि there should be a nexus between the post and parliament. I want to ask you, neither the Bhargav committee said so, nor the Act of Parliament has said so, nor the Constitution said so, nor our framers ever said so. No document, no clause, no book ever says so. Just because one party says so today, we are to create a new legal test. If this is a new legal test, why did we have a constitutional power of exemption? Why was it necessary to provide for exemption in case you had to have a nexus? This is not a test in any situation, in any discussion. And this listing procedure, the listing of certain posts, is a universal practice followed in every country which has an office of profit dispensation. For example, in Britain, the list system is followed. There are no criteria. It does not mean that there cannot be criteria. It means that it is not possible to provide for every situation. Now, he talks about the pendency. मैं समझता हूं कि ये बात कर रहे हैं पेंडेंसी ऑफ इलेक्शन कमीशन की। 103 में, आर्टिकल 103 के अंतर्गत इलेक्शन कमीशन उस कानून से बाध्य होगा जो कानून ये संसद पास करेगा, और अगर ये कानून संसद पास करता है तो इसमें कोई भी बाधा नहीं है कि कुछ याचिकाएं इलेक्शन कमीशन में इस वक्त पेंडिंग हैं। इसलिए ये बिल्कुल बेबुनियाद बहस है और आरोप है कि इस वक्त इलेक्शन कमीशन में कुछ मैटर्स पेंडिंग हैं। The Honorable President's views are of course entitled to the highest respect. The Honorable President's views may no doubt be taken into account by the government in any future dispensation or any future committee which according to the wisdom may decide to embark on a larger exercise. But that cannot be any reason to suggest that this House should not pass this legislation. That is no reason to suggest that this House has less power or cannot or is acting contrary to the Constitution in referring a matter back to the President. The point of the matter is simply this, that you are entitled to practice hypocrisy. You will practice hypocrisy and double standards when you do this all over. You do this in Jharkhand. The Jharkhand Development Authority is headed by a respectable minister. The Chief Minister of Jharkhand heads another authority. At that time, your memories go weak. But when this legislation, this House seeks to recognize a reality, what is this legislation about? This legislation is about recognizing a reality, and that's the real answer. I'll just take 2 or 3 minutes more, Mr. Chairman. The reality is this: for 20, 30 years, nobody has considered these posts. Nobody has considered these posts to be monetary offices of profit. Nobody has considered. Nobody has considered that these are persons who are rapaciously exploiting these posts. A reality existed. Several persons occupied it across parties. Several posts were occupied always by members of parliament and by the Vice President of India. A reality arose in the light of some new developments. There has to be a mechanism to deal with that. The Constitution provides that mechanism to the Parliament, and this bill does nothing but recognize an existing reality. It does not mean that in future a committee may not devise new criteria, but that does not mean that the reality cannot be recognized by this bill here and now. And the opposition to this bill is motivated. It is deliberately intended to create political misleading statements, and therefore, Mr. Chairman, sir, I propose that this bill be passed in the manner presented.
Thank you.